welcome to you all to the Royal Courts of Justice. The reason we're holding this event, and we're delighted you've accepted our invitation, is because it's part of our programme of trying to get law into communities and schools and getting school students into the law. We want to improve people's understanding of the jobs that we do. We want to dispel any myths that may still exist, myths that suggest you can only be a judge if you're a white, male, public school educated person. And we want to encourage people like you to think about a career in the law and potentially a career on the bench. I don't think any of us present on the bench here have ever regretted our decision to become a lawyer, and there are masses of options open to you if you do. So the idea is that we're going to tell you a bit about what we do by answering your questions. So I'm Lady Justice Heather Hallett. I'm in charge of the Court of Appeal Criminal Division, so I hear appeals in all the most serious criminal cases. I also sit in the Civil Division, where I hear appeals in civil cases, things like employment, tax, that kind of thing. And I'll ask my colleagues to introduce themselves. On my right.
Hello, I'm Fiona Monk. I'm the Regional Employment Judge for the West Midlands, which means I'm responsible for judges that hear employment tribunal cases.
Further to my right.
Good morning, I'm Joanna Cutts. I am a High Court judge, which means I'm often, most of the time, here. I'm in the Queen's Bench Division. I'll be telling you a little bit about what that means in a moment. But I only became a High Court judge in October of last year. Before that, I was a Crown Court judge trying criminal cases.
Good morning, everyone. My name is Tan Ikram. I'm the Deputy Senior District Judge. So I'm responsible for 300 judges who sit in the Magistrates' Court. I'm also a judge on a British Overseas Territory, which is called the Sovereign Base Area in Cyprus.
Good morning, everybody. I'm Angela Morris. I am a Crown Court judge and I deal with criminal cases, and I also sit in the First Tier General Regulatory Tribunal to deal with environmental cases and things dealing with either professional regulation or pensions.
Good morning, judges. We would like to ask, could you describe a typical day as a judge?
Thank you for the question. I'm just going to start by saying I'm not sure there's a typical day, because there's not really such a thing as a typical judge. There are so many judges, which is why we've got the panel here comprising people who do different things. But let's find out what they say. Fiona, what's a typical day for you?
Well, there isn't a typical day, but it's always very busy. It's always people-centred. It's often very unpredictable. My role in the tribunals means that I'm responsible for leading a region, so a lot of my day is spent looking at the list, sorting out particularly difficult cases, making sure that all my judges have got cases allocated, and then doing behind-the-scenes case management. But also sitting and hearing cases as well, so it's really varied, and you can never tell when you go in the morning whether it's going to be exactly what you're expecting. Jill?
I think that's probably true in the jurisdiction, in the area that I sit in as well. As I said to you, I've only recently changed. So to tell you a little bit about when I was a Crown Court judge, a typical day in court, hearing criminal trials, pre-trial hearings, sentences. You might not know until the day before which case you were going to do the next day, so it can take a bit of work sometimes the night before, getting in early, reading the papers, making sure that you're ready for your case. I was also the resident judge, so I had a function very similar to Fiona's. So when I was a resident judge, I was also responsible for the smooth running of the court. So in terms of listing of cases, how many cases should come in, when they should come in, what should be the priority cases, which judge should do which case. And I'd also be responsible if things weren't working well in talking to other agencies, the probation service, the prisons, the police, witness support, the prosecution, defence solicitors, trying to get everybody together to make sure everything's running as smoothly as it can, to make sure the cases are coming through, and when they are, they're being heard. So that was very often I'd come in the morning, do a bit of admin, read my cases, go into court, have a meeting when I came out of court, and then think about the next day. All day talking to my list officer, what's coming in tomorrow, which cases have gone a bit short today, what should we be doing? Very dynamic kind of environment. As a High Court judge, in many respects it's quieter. I've got my own clerk, I sit in my own room, the cases are being brought to me. I'm not now in charge of a lot of other people. But unlike where I was before, I'm no longer just doing crime. So the Queen's Bench Division involves quite a lot of civil law as well, administrative law, and I sit in the Court of Appeal Criminal Division, so I might sit with Lady Justice Hallett as one of the constitution of that. I sit on some criminal trials. In fact, I've got to rush off today because I've got to get back to one. I sit and try some civil cases. For example, when one person's suing another person. I spend some days on paperwork, sitting to decide whether I should give leave to appeal to people who want to appeal previous decisions. And once a year, I'm the out-of-hours judge. And it means I can be called up at any time in the night by a professional through my clerk to try and deal with something that's truly urgent. Dan?
So, like my colleagues, I spend a lot of time sitting in court, dealing with young people in the youth court. But last week I spent an afternoon talking about software, because I also have to go to meetings. There are changes going on in the courts. We're looking at how we can use video links like Skype, and how we can have people not physically coming to courts. And one of the things I'm working on at the moment is the software that the courts use, and giving my views, because I'm a bit of a computer geek, on how we can use computers to make us more efficient. So it's lots of things. It's not just about going and making decisions. Thank you.
Angela?
Along with the matters that have already been raised, I deal with community and diversity in the local area where I live, and that involves trying to devise schemes which will encourage people such as yourselves to come to the court, to see what goes on in the courts, to go to schools, to talk to schools about roles as lawyers, as judges, what we do, and also to speak to other agencies, both within the criminal justice system and beyond those in terms of the charitable organisations, so that we can understand where we can actually develop into outreach programmes which perhaps we haven't touched upon and which need to be addressed.
I think we may almost have answered another of the questions that were sent in, because as you can tell from the answers, being a judge isn't just about sitting in court. People see that courts sit 10 till 4:30 or 9:30 till 5 or whatever it is, but those aren't just the hours that the judges work. They're doing many, many other things before they go into court and after they've finished in court. Right, can we have the next question?
Good morning, judges. How far do you think the media influences trials and members of the jury?
Well, I've sat on cases where we've had the unfortunate examples of jurors who've researched a case they were trying, and I'm afraid they've done so in defiance of the judge's orders, and I think Judge Morris can tell you a little more about that in a moment, and they've gone to prison. And it's because we're all influenced by everything we see and read. Whether we know it or not, we're likely to just soak things up. And one of the problems that a trial judge, like Judge Morris, faces is trying to ensure that any influences brought to bear on the juror are fair ones. You know, they've got to be fair to the prosecution, but most importantly, they've got to be fair to the defendant. And if you have a jury reading about the case online, then the chances are it's not going to be fair, because the juror is going to be taking into account material that's not going to be called in the trial. So supposing it was prejudicial to the defendant, what they read online, the defence barrister's not going to know that, or the defence advocate's not going to know it, so they can't challenge it. So material is going before the juror without their realising it. So I think the answer to your question is I think the media has a huge influence. And I think particularly in your world, where the social media is so important. And it's a real problem, trying to make sure that our jurors aren't wrongly affected by what they see and read.
And that is why when people are summoned to come to court as jurors, they are first of all told downstairs by the jury officer about their responsibilities as jurors. They are then, when they are brought to any particular court as part of the panel, and impanelled. Once that jury panel has been sworn, the first thing that a judge must do is to explain to the jury and all of the jurors their responsibilities. And one aspect of that is about how they are trying the case. And the case that they try, they take an oath that it is on the evidence, which has to be explained to the jury at the very beginning, that that's what they're going to hear in court. And it's important that the judge explains to the jury that it is only on the basis of what they're hearing in court that they must determine the case, because there is a risk that if they are influenced by things outside of the courtroom, that it might derail a trial, and also that can cause huge anxiety for the parties in the trial, huge public expense as well if the trial has to be delayed after a long period of time. And most jurors are very responsible and they do take it very seriously. But unfortunately, set against that, you also have, of course, the fact that we live in an open society where the important aspect of freedom of the press, first of all to report cases, is taken into account. That they do so responsibly. Unfortunately, that doesn't always happen. But we try our best to explain everything. And now, in fact, once the judge has performed their role of explaining to the jury, there are leaflets that are given to jurors as well at the conclusion of the explanation given by the judge, that they take away with them, so that it reinforces everything about only trying a case based upon the evidence that they hear in the courtroom and nothing else.
But it is a real problem. I mean, despite all the instructions jurors are given, you still find jurors will just go off and start researching that case and that defendant. And it can cause, as Judge Morris has said, it can cause a collapse of a trial, and that will involve not only a large sums of money being wasted, but also sometimes a complainant who's given evidence about a really, really distressing incident will have to go through it all over again. So I'm afraid it's something that jurors just mustn't do. But don't let that put you off being a juror, because there's an interesting piece of research which shows that those who sit on juries are more likely to participate in democracy by voting. So sitting on a jury is a really good way to contribute to society. So don't be put off, just listen to the jury's instructions if you ever get the call, and you should be okay. Right, third question.
Good morning to you all. Given recent news, do you think there should be harsher punishments for under-18s knife crime, so to act as a deterrent?
It's a very topical question. And when I saw the question, I A, thought how topical it was, but B, I checked the Sentencing Council guidelines. All judges and magistrates, when they sentence people of whatever age, must bear in mind guidelines produced by the Sentencing Council. And the idea is to give people a structure, sentences a structure to sentence people on, and to promote consistency across the country. So in other words, you don't get 6 months in one court and 2 years in another. So the idea is that they have to follow the guideline. And I looked at the guideline, and I think some people might be quite surprised as to how apparently harsh it is. If you are under 18, if you're between 16 and 18, for possession of a bladed article, a knife, say, you're talking about custody, straight in. Now, that will have to be balanced by all sorts of other factors, and I know that Judge Ikram could tell you more about that, because he sits in the youth court, as he said earlier. And it's not an easy exercise, because as we all know, knives cause the most dreadful misery on the streets. But there may be reasons why the defendant says they have a knife. Describe a sentencing exercise.
People under 18 are really present a challenge, because you're trying to change them. They're really young. And they're still at that stage in their life where they're learning and they're changing. So we have to have real concern about their welfare. But the offences you're talking about are serious. And as has been mentioned, there are guidelines. In fact, the guideline, there's also a case. And what judges do is we also look at previously decided cases. And there's a particular case which says that if you have a young person who has carried a knife, they go straight to detention. And that is now the starting point. Of course you look at every case, of course you look at every single young person separately. But, and here's the key thing, and you've used the word yourself, deterrent. Because part of what we do, and it's only part of what we do, is send messages. And one of the messages which this case says we must send, or certainly consider sending in every case, is the message that if you carry a knife in public, then you're going to go into detention. So that's where we start.
And as the judge was saying, what we do, we're balancing a number of laws as well as principles. So Parliament has laid down minimum terms of detention for young people caught in possession of a knife. And the court has to impose that term unless there are exceptional circumstances. On the other hand, Parliament has also said, but you have to look at the welfare of somebody under 18 when you're sentencing them. So you've got all these different balances that you're trying to bring into play. And it's not always easy to try and get the right decision because, if you read of somebody who's been killed because somebody was carrying a knife, felt threatened and produced it, and then you read the story of the person who was carrying the knife, that they were carrying it for their own protection, you see all the different things. But I'm afraid the ultimate message is don't carry a knife if you don't want to go to prison.
What skills and characteristics do you think make a good judge?
Joe?
Patience, the ability to listen, and I mean truly listen, because it can be difficult sometimes. You read a set of papers, this is a real learning curve, you read a set of papers and you think to yourself, I don't know, this one looks pretty bad, or whatever it is, and you can go in and someone's completely different. You have to listen. And that can be very difficult too when you have, and you certainly have here, as I've been a High Court judge, with some people coming in wanting an injunction, wanting you to stop something happening, and they're not represented. And they come in and they don't know the law, and you have to listen. They don't structure it in a way that you would expect it to be structured. You have to kind of work out that there's something there that they really have a point they want to make to see whether or not you can give them the injunction that they want. So you have to be able to listen and put aside any view you have really going in, to properly listen and not be coloured by your own view before you go. And you have to be able to communicate, because there's no point listening if you can't then explain to somebody why you're doing what you're doing. So if you're sentencing someone, a young person with a knife, you have to be able to explain to them in language they're going to understand why you're doing what you're doing. You're going to have to be able to explain to your person who's coming, who's not represented, why you can't do what they want you to do. So I think it's patience, it's being able to listen, it's being able to communicate, and it's also behaving courteously towards everybody that walks into your court. Sometimes they can be difficult.
Anything to add, Fiona?
Yes, I think Joe's summed up really the qualities that we'd all agree on. I think there are a couple of others around being able to think very clearly through often what are quite muddled factual situations or complex legal situations, but also a degree of personal resilience, because often what we're dealing with are very distressing situations for the people who are appearing before us, or maybe upsetting for some other reason, or we may be feeling under a lot of pressure because of the sheer volume of cases that we're dealing with. One of my roles is on the Judicial Appointments Commission, which is responsible for appointing the vast majority of judges, and the skills and abilities that are looked for when judges are appointed really are those that Joe's already outlined, but are around the ability to exercise judgment, having the ability to have the necessary knowledge or acquire the necessary knowledge, so you've got to be able to understand the law, but also around being able to communicate with people and treat people properly and manage your own work efficiently. So I think we're really saying the same thing in a different way, but yes, those I think are the crucial skills that we look for.
Anybody anything to add, or no? I would just emphasise, both the judges on my right spoke about communication. It's because I believe so firmly in the art of communication and its importance to all of you, whatever you do in your lives. the better you can communicate, the more likely you are to achieve success. It's why I work with the Shakespeare Schools Foundation, whereby we get young students on the West End stage, and I get to appear on the West End stage, which is great. Or maybe I'm not great, but it's great for me. But it's being able to communicate with people. It will help you fill in forms if you want a job. It will help you in interview when you're being interviewed. It will help you throughout your life, persuade people to trust you, to employ you, to like you, and it will just be the kind of art that you need. So can I encourage you all to get your teachers to make sure that they are doing things with you that will help you all learn the skills of communication, because it helps you as a lawyer, it helps you as a judge, but I'm confident it would help you in other things as well. Next question.
Good morning, judges. Our question is, how can we make UK laws better reflect the diverse nature of British society?
One of the principles we have is called the separation of powers. And what that means is that the law is made by Parliament. So in fact, they make the law and we interpret the law. There's another principle some of you may have heard of called the rule of law. And central to this idea of a set of laws is that everyone is equal. The laws apply to everyone, and everyone appears as an equal in the courts. So that's a principle which is universal. Now that doesn't mean people are not different, because everyone who comes to court is a different individual, and we take that into account. So the answer is, in fact, we as judges don't make the law at all, but the law itself recognises that everyone is equal.
What was the most difficult case that you have had to judge, and why?
I will always say the most difficult case I ever had to judge was the inquest into the victims of the London bombing, 7/7 inquest. The stories that you heard from the bereaved families, from the survivors, some of whom had lost almost literally half their body, and it was a miracle they survived. And the rescuers who had to go into the most appalling situation in the dark. You imagine the tube train down below where bombs gone off. Just hearing their stories, hearing their dignity and their courage, and maintaining one's own professionalism, because it's one thing if you're sitting at home watching a really moving account of something and you can cry or you can feel terribly sad, but if you're in court and you're the judge or the lawyer, you've got to stay totally professional. And when you hear stories of that kind, it is really, really difficult to maintain one's calm. Somebody once taught me a trick that if you think you're going to become emotional at a time when you don't want to be, you stick your nails into the palm of your hand. And I think there were occasions when I came out of some of the hearings when I was almost bleeding because my nails had been stuck so firmly into the palm of my hand. Anybody else, Tan? You got a hardest case?
24 years ago, I read a textbook when I was at Polytechnic, and it was about the law where people take things which are not theirs, and they're not entitled to hold on to it. And that's something which I vaguely remember from 24 years ago, is the law of the tort of conversion. Now, I haven't looked at that law ever since I passed my exam 24 years ago. On Friday, the lawyers brought all their papers, put them on my desk and said, "Make a decision now, will you please, about the tort of conversion." And I thought to myself, I'm not quite sure what the tort of conversion is, because I just hadn't looked at it.
You didn't ask, what am I doing here?
Well, you'd be surprised how often I ask that question to myself, in fact. And that's what happens. Judges sometimes have to deal with things which they may not immediately know the answer to. But everyone expects us to know the answers there and then, because the judge apparently knows everything. Well, sometimes it's not true. So I found, I have to say, last Friday quite tricky, and I'm now thinking about what I'm going to do on that case.
Andrew, did you have a hardest case? Or?
I think probably a planning case, which I had never done anything about planning before. And it was a case in the Crown Court, which is rather unusual because it was to do with something called an enforcement notice and something I'd never heard of before. The way that the investigation had gone on made me concerned to the extent that there was an application for me to stop the case. And that's a very, very big responsibility for a judge to take, because first of all, it can only be in extremely exceptional circumstances that a judge should step in to stop a case. It is the jury's determination, that's 12 people who were coming along to make a decision about that, as to whether or not the person is guilty or not guilty. And so only in very, very rare circumstances should one do that. And this was one of those cases where, having looked at all of the law, and there was a very considerable amount of it, which I have to say took me quite some time to read and understand and digest, because it wasn't my field of expertise and I had to get to grips with it, I came to the conclusion that applying the principles from the criminal sphere, that I had to stop this case because it was an abuse of the process of the court for it to continue. And I realised that by doing so, it was going to have an effect upon the party who'd brought the case, because it was a local authority case, and so it was going to have an enormous effect upon their funding, because they're cash strapped like so many. And it was difficult, but it had to be done.
Came to me on appeal, and I had the sense to get in a planning expert to sit with me, so I didn't have quite the same problems. Joe?
I was thinking about this one because there can be many, many difficult cases you have to try for all sorts of reasons. And I've had a similar experience to those that have been spoken about already, especially now becoming a new High Court judge in areas of work that I haven't looked at since I was a student. But I think one of the cases that lodges in my mind is when I was a Crown Court judge, and there was a trial of 4 people where a very vulnerable person who'd had a very difficult life had to give evidence and be asked lots of difficult questions. She was quite damaged, and she was going to be in the witness box a long time. In fact, she was there for much longer than she needed to be, because she was the most difficult person I've ever had to handle. And I had to recognise she was damaged. And she would shout, she would scream, she would ask questions of counsel, she'd be very unpleasant. At one point, she whipped out some tablets and started taking them. I had no idea what she was taking in the witness box. It turned out to be Valium, but of course you have to know. I had no idea what she was doing at all. She would leave court, she would be upend tables. It was because she was damaged, and she was having to talk about her past life, and she was being asked questions about her past life, which had to be asked because I had to be fair to the people who were in the dock. So it was managing that, managing the questions, when we should take breaks, trying to manage her and make sure that she stayed long enough for her account to be given, so she didn't just storm off and never come back, because that wouldn't have been right, but also to make sure that the people who were asking her the questions were only asking the questions they actually had to ask. So I think that, as a balancing exercise, was probably one of the most difficult things I've had to do.
Yeah. I think probably the first case I ever sat on was the hardest one, because you suddenly realise that you've got to make a decision, and it's not quite like being an advocate where you putting one side of the argument. You've actually got to hear both sides and make the decision. But echoing what others have said, the one that sticks in my mind is one that involved a very, very sad story. An individual, it was in a different tribunal from the one I normally sit in, so it's in a tribunal called the War Pensions Tribunal, and it involved a serviceman who'd gone missing when he'd been abroad, and his wife thought something strange had happened, didn't accept the official explanation, that he was declared as dead, and she was bringing a claim for compensation. And there was a huge amount of upset and distress, and you had to manage that in the context of the hearing and yet come to a balanced decision. And it's those cases, I think, where you have to put aside to a certain extent your natural sympathy whilst you're still empathetic and you're still able to listen to the story and make sure that you hear the full story, but that you have to reach an objective decision at the end of the day. So those are the hardest cases, I think.
Thank you.
Good morning, judges. What is the judiciary doing to encourage more female judges and to increase representation of judges in the highest position? Also, what is the judiciary doing to encourage judges from ethnic minority backgrounds?
We're doing as much as we can with the resources that we have, is the honest answer to your first question. I am chair of the Diversity Committee of the Judges' Council. So the Judges' Council comprises all the judges, so the judges in the court service, the judges in the tribunal service, and magistrates. And we basically do everything we can to promote mentoring, work shadowing, job application workshops, outreach events. And at some of the outreach events, we just get a panel like this, and we just describe our journey to the bench. And we do so because one of the myths I was talking about earlier is the myth that to be a judge you have to be the white male public school educated. And people are often astonished at the backgrounds that some of us have come from and the kind of fights that we've had to have to get to the bench. And so we've found that when you have positive role models, when you have work shadowing, when you have support and information provided to people, it really helps them think about, well, maybe if that person got through, then maybe I can as well. As far as BME lawyers coming judges are concerned, I know that Tan does a great deal with the BME community. Tan, do you want to describe some of the work we do there?
I sometimes wonder whether the reason people don't put themselves forward, whether it's at school or for a particular job, is they think they're not good enough. Or they think other people are better than them, or they think they don't want people like me. And so we create our own barriers. We do it to ourselves sometimes. We say, you know, I don't think they'll even think about someone like me. So one of the messages we get across, or we try to get across, through everything we do, is that it is people like us, people like you in this room, who are going to be tomorrow's lawyers and then tomorrow's judges. Because, of course, all the judges start off as lawyers. So a lot of the work that myself and Lady Justice Hallett do is we're talking to lawyers in all sorts of different circumstances, just sharing sometimes where we come from. Because where you start recognizing someone as somebody, yeah, they're a bit like me, and look, they're sitting up there now, then you start getting rid of some of those barriers. So yesterday I was talking to the Middlesex Law Society, and I was talking to them about what we do in the youth court. But I took it as an opportunity as well to introduce myself and the fact that my mum and dad worked in a factory and they were postmen, that I went to a polytechnic, that I'm a son of immigrants, etc., just to get those messages across. And I think when people start understanding that it's not all white old men who become judges, that it is people like us, then they're more likely to apply. So we try to use lots of different opportunities to get those messages across.
Mrs. Justice Cutts and I were sitting in Winchester. We took the Court of Appeal to Winchester on Tuesday, and also down in Winchester is a judge that Mrs. Justice Cutts suggested would have been great for this panel. He's now a High Court judge, and Sir Akhlaq Chowdhury, he would be called out of court. And we discovered that he was born in Winchester, which, if you heard his broad Scottish accent, you might be surprised about. We certainly were. And he described the journey of his parents had come to this country from Bangladesh. His father had started as a docker at Portsmouth, had then become a waiter in Winchester, hence the arrival of little Akhlaq Chowdhury, as he then was, in Winchester, and then had gone to Scotland to work in an Indian restaurant. It was just this wonderful progression. And there are lots of people. We're not just picking examples that are rare. There are many, many examples of people. It doesn't matter what your background. If you're good enough and you have the right qualities, then we want you. Don't think anybody's anything else to add. So thank you for the question.
Our question to you is there now a future for judges with the advancement of artificial intelligence to access and make decisions?
Joe?
I'm going to start by saying I don't know much about computers, but I know enough that when I go onto the internet, it's piling lots of adverts at me, which they know I will like because they're monitoring my life the whole time as to what I'm searching on the internet. So I know enough that, that there's a lot going on there. And so I'm going to come at this not really from a computer point of view. I have no doubt that we will get to a stage where if you fed in every decision of the courts, as I think we've discussed before, we very often look at previous decisions to help us make our decisions. If you put all those decisions in, that you will get a computer that will come out with a decision. I've no doubt about it. And it may be that the computer might be able to work out from previous decisions sort of what might be the case. But where I think it would be lacking, until such times as someone builds it otherwise, and to a certain extent I hope they don't, where it would be lacking is that no two cases are ever the same. You can have in front of you 2 cases to sentence on the same day, where you'll send one person to prison and the other person you won't. And the reason for that is because although the offence is the same, the circumstances are different. There is a place, as has been talked before, for a judge to be merciful in the right case, to have compassion and understanding as well as having to balance what they have to do, to have humanity. And I don't know, maybe we're going to get to a stage where algorithms will have humanity, but I doubt it. Can I just give you an example? Someone could come into my court when I was a Crown Court judge, in Judge Morris's court now, who's drug dealing. Judges don't like drug dealers, they go to prison. Really, that's the end of it. And you might have someone in front of you, it came back to what I said earlier, that you're sitting in your room reading it thinking, yeah, right, this guy's going to prison today. And you walk into court and he's got a long criminal record, he's done it before. Why should this guy get any chances? But there's just a glimmer that he's turning the corner. Just a glimmer that if you keep him out, he's ridding himself of his drug addiction, he's starting to move in the right direction. Do you take a chance? That's part of a judicial decision. I doubt your algorithm would ever take a chance, but your judge would.
Thank you very much. And will you forgive Mrs. Justice Cutts because she has to get a train? Thanks, Jo. Right, next question, please.
What is the hardest thing about being a judge?
I think for me the hardest thing is, as in anybody trying to do a professional job, you do your very best to do it properly, to bear in mind all the relevant factors and eventually reach your decision. And I suppose the hardest thing is, having gone to all that effort, is then to find that it's been misreported somewhere in the media. And it's not deliberately done, but it'll be done because maybe people haven't really understood all the factors that we have to bear in mind. And it's tough, you know, when you've really tried your hardest, and then to be criticised for what you think is totally the wrong reason, and that people haven't really understood what you were trying to say. I mean, maybe we should get better at communicating. It's one of the reasons we have events like this. We're trying to get better at communicating with people. And I think judges in their sentencing remarks, for example, these days, are getting better at explaining what they do. And so I think we just need to perhaps be a little more understanding of judges. Sometimes they do have a difficult job and they're not trying to make everybody else's life a misery. And so I think I would ask for a little more understanding. Chan?
I was a criminal defence lawyer for 13 years, so I represented people who were accused of crimes. And when I was made a judge, I sat in a criminal court. But then I ended up sitting in the family court making decisions about children and whether mums and dads could safely look after their kids. And I had to make decisions about whether children should be taken into care or whether they should be looked after by foster care parents. And like all judges, I want to get it right. I want to go home proud of my decision, knowing that I've got it right. I found that really, really difficult because I used to go home every night when I was dealing with family cases. Interesting, not with criminal cases, but when I was dealing with family cases, I used to go home wondering whether I'd got it right. And that is really, really difficult. And one of the things about judges is we don't actually find out what happened next. We make our decision, and then other people take over, and then they do what they have to do as professionals. So I never, ever found out whether I'd done the right thing or not. That, for me, was difficult.
Angela?
Making decisions which might affect the outcome of a trial. To give you an example, it may be a decision as to whether or not a person's previous convictions are brought before the court and the jury know about them, because that might influence a jury as to whether or not they're going to find a person guilty or not guilty. And those are difficult decisions, and I echo what's been said, that we try our best to get those decisions right, and that only in the right circumstances does information such as previous convictions go before a jury, so that there is no disproportionate influence brought to bear by things such as that. Because it may be that, using that example, if the previous convictions don't go before the jury, the case may go one way, or if they do, that the case may go another. And so that's why it's very important to do the best we can to try to make the right decision. Not always easy.
I'm going to say really the same as everyone else, which is the hardest thing is making the right decision and being sure you've made the right decision. All of us as judges are really very aware of the huge responsibility we carry, and want to make sure that we make the right decision in any given case. And for us, the people in front of us, maybe their only time in a court or a tribunal, and it'll be something that's really, really important to them. And whilst it might be our everyday job, that doesn't mean that we're not conscious that we've got to make the right decision every single time. So I'll echo what others have said, that it's about making sure we make the right decision.
Our decisions affect people's lives in drastic ways, as people have said. And I was thinking back to what Mrs. Justice Cutt said about if you think there's a glimmer of hope to a drug addict. Years ago, when I was still a trial judge, I passed a sentence on a drug addict where I thought there was that glimmer of hope. I mean, everybody else said this chap should go inside for a long time. But I thought there was that possibility that he might turn his life around. The sentence I passed was so merciful, and I'm not known, I don't think, for passing soft sentences, but it was so merciful that they even went to the Attorney General to ask if it was an unduly lenient sentence, whereby this court can increase the sentence passed at the Crown Court. But I'll never know. In fact, the Attorney General said no. The judge was entitled to give this chap a chance. But I'll never know. And it goes back to what Tam was saying. I would love to know whether that drug addict turned his life around, but we don't find out. So we make these decisions that impact so much on people's lives, but we don't have the follow-through, which is a shame, really. Anyway, so there we go. Thank you. Next question.
Our question is, how effectively can UK law adapt to fit the effects of leaving Europe, and will UK citizens be as well protected as they were under European human rights laws?
Well, there was a referendum, and the people decided they wanted to leave the European Union. The European Union has its own court, and it has its own laws. But the European Convention on Human Rights is something completely different. We signed a treaty by which we adopted the European Convention on Human Rights, and then we had the Human Rights Act, which effectively brought it within English law. But what people sometimes forget is they are not the same. The European Convention on Human Rights and human rights law has nothing to do with the European Union. So the answer, in fact, is, as far as the convention is concerned, it's business as normal. That isn't going to change.
I think it's one of the misunderstandings that people had certainly some of the reports I read of the impact of leaving Europe, there will still be cases going to Strasbourg for decisions unless we leave the European Convention or repeal the Human Rights Act. So I think, as just been said, that we should be all right. As far as human rights law is concerned, I make no comment about anything else.
Do any of your cases or work take place outside the courtroom?
I don't know if we've answered this to a large extent already, given the amount of administration that we do, but Fiona, do you want to just describe perhaps a little more detail what you were saying earlier?
So lots of my work's outside the courtroom or tribunal room. Lots of what I do is around running the region. I also have responsibilities for the modernisation programme that Tan's already touched on, that's affecting courts and tribunals. So a lot of my time is spent in meetings or with colleagues, and also lots of the work that goes on around specific cases, it isn't done in the hearing, so it's not visible, it's done behind the scenes. Cases get referred every day to me or to other judges to make decisions on that help move the case through the system. So what you see, what the public see in a tribunal is very much the tip of an iceberg. There's lots of preparatory work that's gone into that particular case that doesn't happen in the hearing room, but there's also all the work that goes on keeping the tribunal system running and keeping judges working and happy. So yes, lots goes on that you don't see, and lots goes on outside the actual hearing part of a case.
Same applies to me. Because I'm in charge of the Court of Appeal Criminal Division, I've got to make sure that the Court of Appeal office have all the support that they need. We have lawyers there, we have administrators, and they combine together to prepare all the papers for us and get things moving. My job is to ensure that essentially the judges feel that they're getting the support they need and the officials and the lawyers feel they're getting the support they need. I also have to monitor the list. So I think one of the questions somebody did ask, I don't know if we will get to it, was who puts the cases in front of you. Technically, it's likely to be an official will decide, right, Judge Bloggins is going to do the cases of X, Y, and Z tomorrow. But ultimately, it is a judicial decision. It's for a judge to decide who will try cases. And the reason for it is that we don't want there to be any kind of perception that somebody has got the judge that they wanted. So we insist that listing is what we call a judicial function. In other words, the judge will ultimately decide, which is why I think Mrs. Justice Cutts was talking about when she was a resident judge at Reading, she was trying to work out which judges would do which cases. And it's to maintain that element of independence and to ensure that people can't say, oh, well, that judge has always been in favour of X or Y. There's a great deal of work goes on outside of court. I don't know if anybody, I mean, I know that Judge Morris is currently planning her open day. That's one of the things you're doing out of court.
It is, yes. A lot of that work goes on after the court hours are finished. But to give you an example of cases which are in different venues, my local court is Reading, and I sat with Judge Cutts, and there were occasions when, as a Crown Court judge, I'm sitting in court for most of the day hearing cases, but sometimes I sat at Reading as a tribunal judge, and because those cases were what are called paper cases, so it meant that the parties had agreed that they didn't need to come to make any more representations. I could sit in my room and deal with those cases in my room. So although I was actually at Reading Crown Court, I wasn't actually in the courtroom as such. I was in my private room dealing with judicial determination. But over and above that, there are many other things that we're dealing with. And yes, the open day, which we are going to be having later on this year, if any of you happen to want to come down to Reading, you're very welcome, is now in full flight, where we are looking at doing mock trials, and we are making invitations for schools to come and do art competition. And there are going to be talks by various organisations from different areas of the criminal justice system, and we've just managed to secure as well Thames Valley Drugstore, who's going to come and be the star of the show for that, to demonstrate all of that. And so yes, we do a lot of work outside of the court hours as well in respect of matters which aren't purely the judicial function.
Lots of court centres do open days, so if ever you are thinking about, you'd like to learn a bit more about the law, or about being a lawyer, or about being a judge, please look out and see if there's one near you, because I bet you Croydon, I think some of you come from near there, Croydon I'm sure would do an open day, but check them out, they can be quite entertaining. And Judge Ikram helps run all the, what used to be called stipendiary magistrates, but are now called district judges around the country, so you probably have a huge amount out of court too. Yeah, we do things like the meetings I was speaking of earlier. I'm also responsible for training, so I help prepare training programs for judges. And like everyone on this panel, in fact, a lot of the work we do is volunteer work outside court hours as well. So last Saturday, for example, I was at a university in London where we'd put on a competition for students from schools across London in relation to presenting arguments. And we had various judges judging how well they did in terms of their presentation. And the reason we do that is that it's great for us to learn about everyone around us, but it's also an opportunity for people to meet us as well. And that's really important, because a lot of people still think, wow, I've never met a judge. And when they do, they see we're ordinary people. And that's really important as well.
Did you all become judges by design, or are any of you surprised to be where you are today?
I think I know the answer to this.
I went to university to study electronic engineering, and that's where I started, because Dad thought I should become a doctor, but I thought I was very good with my soldering iron, so I'd be very good at electronics. I ended up selling mobile phones for a couple of years, and then I became, as I say, a criminal defence lawyer. I never thought in a million years that I'd be a judge. So if you're asking me the question, am I surprised? Yeah.
Angela?
I read law at university because I didn't have a clue what I wanted to do with my life, and my stepmother said, well, if you don't know what you want to do, go and do a law degree, because you never know, you might have the opportunity to go in any one of many directions. I didn't start out as a lawyer. I went and worked as somebody in the City of London, and only then, when meeting barristers and judges, did I get the inspiration to think, I want to go back and do that. But I never for 1 minute thought that there would come a day where I'd be sitting on the bench as a judge at all. And I still wake up every morning thinking, is this me? Is it really me?
Fiona?
Yes, I'm incredibly surprised. I think if you told my 16-year-old self where I'd end up, I'd have probably run out of the room screaming, thinking that's far too scary a thought. I did do law at university, and I was really fortunate once I'd qualified as a solicitor to find, really I just stumbled across an area of law that I loved, which was employment and discrimination law, and I worked in a law centre which gave me a lot of opportunity to appear in the employment tribunal. And it was really just a chance comment by a tribunal judge who said, oh, you might want to think about doing this at some point. And I don't think it would have occurred to me in a million years, as Tan said, that I'd end up then becoming a judge and sitting on the other side of the bench. So I think what all of us are saying is you can't plan what life's going to bring you, but make the most of the opportunities that there are and have some confidence in yourself that you can do things that you might at this age think that's far too difficult or it's not for somebody like me. Make the most of the opportunities that life brings your way.
And make the most of opportunities despite the fact that other people may think that there are too many difficulties in your path. My teachers said I wasn't fit to go to university, and they said if I thought about it, I might possibly be able to become, go to a training college and become a domestic science teacher. Well, my sons will tell you that's quite a laugh, given my skills in that department. So the fact I became a lawyer was a bit of a surprise to me, and certainly to my teachers. The idea of becoming a judge was just something I never thought of. As I went through, the great thing I found about being a lawyer was I thought that all I wanted to be was be a trial lawyer. Then I managed to get to be okay at that, so I thought, right, now what? Then I thought the best thing to be would be a QC, standing up in court one at the Old Bailey, saying, members of the jury, this is a murder trial. I thought that was the best thing you could ever have. And then I managed to be okay at being a QC, and then thought, okay, now I can become a judge. And you can move between different kinds of things, and each time you're being presented with different challenges and opportunities. And all I can say is I'm absolutely delighted with the job I've had. It's been a wonderful job. They're making me retire this year because I reach official judicial senility. So I have to retire. So I'm going to have to find something else to do that has as many challenges and has as much interest. And it's not lonely. I can tell you there's this myth out there that being a judge is lonely. It's not. It's very collegiate, and it's very friendly, and it's very supportive. So in conclusion, can I just ask you if you are in any way interested in the law generally, in becoming a lawyer, in becoming a judge, do, as Judge Monk said, do check out the opportunities. There are loads out there. We're preparing a package of materials that we're going to put online so that teachers can use them and judges can use them when they go into schools. There are many organisations that combine the law and students. So please look out there, go to the open days, go to an outreach event, because you might be surprised at what you see and you might enjoy the prospect of becoming a lawyer. So good luck to you all, and thank you very much for coming today.